Hi, this is Ken Medenbach. I'm one of the Harney County Resource Center occupation defendants that was found not guilty last year. I previously did a video about the constitutional oath of office of federal judges and how they're violating their oaths of office to start with by taking a second oath of office. Anyways, I want to talk more about this time about the power of the federal government to own lands in the states. Let me start off with the Declaration of Independence and how important states' rights were to our founding fathers. This is the last paragraph of the Declaration of Independence, and it states, "We therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions due in the name and by the authority of good people of these colonies, solemnly publish and declare that these united colonies are and of right ought to be free, independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free, independent states, they have full power to levy war, conclude peace, contract alliance, establish commerce, and do all things and acts which independent states may of right do. And for the support of this declaration and a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortune, and our sacred honor." So, states, independent, free, sovereign states, except for obviously the declare war, those issues are brought up in the Constitution as to who has that power. But these men, 59 of them, I believe, they signed a death warrant when they wrote this, and as divine providence showed, we ended up winning the war, so we got our independence. From 1777 till 1787, we were governed under the Articles of Confederation. And in Article 2 of the Articles of Confederation it states, "Each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and right which is not by this Confederation expressly delegated to the United States." Once again, free, independent, sovereign states were predominantly the thought of our founding fathers. Then here in our own Constitution, under the Bill of Rights, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." Once again, a free state. So now here in Oregon, we have 53% of the lands here under the authority of the federal government, unconstitutionally. And once again, as I mentioned in my last video, the federal government doesn't have the power to interpret the Constitution. We, the people, through our elected representatives, have the power. But anyways, I'm going to go ahead and read you from this seminal case of U.S. versus Gratoit, which all subsequent cases have referred to as the seminal case. It was in 1840, and it was an argument over a lead mine that the federal government had in the territory of Indiana, which eventually included the state of Illinois. And at that time, it was in 1807, they were making a lot of money off this. They were trading out lead for payment of the company that was working the mine. And there was this fellow named Gratoit who was working the mine and getting all this lead out of it. And a certain percentage it was getting, I think 6% was given back to the federal government as payment for the the mine. But then Great Toit stopped making his payments, and the federal government sued him and took back the mine. But part of their argument was that they, under the Article 4, Section 3, Clause 2, it states the power to dispose of and make all needful rules and regulations respecting the territory or other property of the United States. This is the power that the federal government has. Well, in 1807, Illinois hadn't been a state yet, and it was a territory. And in 1818, Illinois became a state, and this case came up here in 1840. So now, when Illinois became a state, somehow the federal government was able to keep this land, and I think they kind of just did it unbeknownst to anybody, and they just kept it because nobody said they couldn't have it. But in 1840, then this case came up here where they're trying to take this lead mine away from this Great Toit fella, and they stated, and this is real similar to what they did in the oaths of office. They started using different words than what the Constitution said. You know, the Constitution said, you know, judges both of the United States and the several states shall be bound by oath to support the Constitution. Well, in 1789, they changed that to a second oath of understanding agreeably, which they ended up using in Marbury versus Madison as a justification for the power to interpret the Constitution to the federal government. Well, here they did the same thing. You know, like I said, you know, Congress will have power to dispose of and make all needful rules and regulations respecting territory or other property belonging to the United States. Well, here they come across and say the words dispose of the public lands used in the Constitution of the United States cannot, under the decision of the United States Supreme Court, receive any construction than that Congress has the power in its discretion to authorize the leasing of the lead mines of the public lands in the territories of the United States. Where does this public lands come in that picture? The Constitution says territory or other property belonging to the United States. Here they say, dispose of the public lands used in the Constitution of the United States. Well, it's not in the Constitution of the United States. And then it even goes down here where it states that the public lands in the territories of the United States. Well, in 1840, Illinois was a state. It's not a territory, and there are no public lands in the states. There's nothing in the Constitution that says the federal government has the power to own lands in the states. And of course, you know, the 10th Amendment states the powers not delegated to the United States by the Constitution are reserved to the states or to the people. Well, since there's nothing in the Constitution that says the federal government can own land in the states, they can't own lands in the states. But once again, here Congress or the Supreme Court is using these obscure words that are not in the Constitution. They use, you know, public lands, and further on down here they use well, they even use property in another case. But of course, property, you know, as I've found in the Oregon Territorial Act, that property, because it states right in there that the lands or other property of residents shall not, or non-residents shall be not taxed any higher than the land or other property of residents. So the word other property there has a completely different meaning than lands. It means appurtenances to the land, improvements that landowners made on their property so they could get taxed on it. And of course, you know, 43% of these lands and other property were foreclosed on by the federal government, so they had to have a means of taking care of this other property. And this is what the other property is. It's these appurtenances to the land. It's not land. Even in Article 1, Section 8, Clause 17, Congress will have authority over places purchased by the consent of the legislature of the state of which the same shall be for forests, arsenals, magazines, dockyards, and other needful buildings. There's no land allowed. It's just places. They can purchase places, meaning they can purchase a lease. They can purchase an easement to the property, but they can't purchase the land, because once the fort, arsenal, dockyard, magazine, or other needful building is gone, the federal government has no more authority over that place. Recently here, I just had a case that I went down to the Nevada to see the trials for the defendants that are being tried for the Bunkerville standoff. I was on probation and wasn't supposed to leave the state, and I asked my probation officer I wanted to go down to the trial, and he wouldn't let me, so I just went anyways. I figured, I've been in court enough times to understand that there's a lot of arguments I can bring up in court once I get in there, and I look forward to going to court, because it's an opportunity to voice my opinion that people will listen to. But it was so I got charged with violating my probation. I had to spend 3 weeks down in Pahrump. Of course, I got to visit with Clive and Bundy and Ryan Payne and Pete Santilli and Jerry Demure. While I was in there, and these guys are all from the standoff down in Bunkerville, so it was kind of almost like a vacation to me. But I ended up, getting my Matt Schindler, my standby attorney, was able to get me released down there within 3 weeks, and then I came back and went to a hearing here with in front of Judge McShane, and I just Matt Schindler explained the probation thing, and then I had a chance to talk to the judge about where my head is at, and I was able to explain to him that shortly has to do with the oath of office, and then I wrote some letters to the United States Forest Service and BLM over in Grant County, and basically in those letters I explained that the federal government doesn't have the right to own these lands, but I also was able to tell them something about our Oregon Constitution, which is directly in line with our U.S. Constitution. And here, under Article 1, Section 1 of the Bill of Rights of the Oregon Constitution, states, "We declare that all men, when they form a social compact, are equal to right, that all powers is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness. And they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper." Wow, those are powerful words. Some of these sentences came right out of the Declaration of Independence. And then, of course, in 1859, the Oregon Constitution was found in conformity to the Constitution of the United States in the Oregon Admission Act. So this is just an extension of our federal Constitution. And then our Second Amendment, a well-regulated militia being necessary to the security of a free state. And I was able to bring this up in front of Judge McShane, and he asked me, he said, "Or do you plan on forming a militia in Grant County?" And I told him, well, I have that option. And of course, I didn't know what was going to happen. I figured I'd get thrown back in jail. But they just put me on 2 months of supervised or probation with this ankle bracelet on my ankle, and see what happens between now and then. But once again, I just wanted to mainly the point I was trying to make here is that in the U.S. versus Great Toit, once again, just like the oath of office of federal judges, they start using these words that are not in the Constitution. As I explained, territory. Well, I haven't explained that yet. Territory is land outside the states. It's what states are made out of. But once it becomes states, they are no longer territory. And other property is appurtenance to the land of our homesteaders. And of course, the government had to be protected once they got those lands back. So that's why they have, Congress will have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Well, these foreclosed properties became property of the United States. And under Article 1, Section 8, Clause 17, Congress will have authority over places purchased by the consent of the legislature of the state in which the same